Okay, welcome back. We're going to start our next panel session. So this very important question, right? As Dean Ring said in her introductory remarks, getting IP protections right are critical to the economy, to innovation, and so very excited to have this panel on IP protections. Have we gone too far? Which, also could raise the question, have we gone far enough in some cases? And so we're going to have a diversity of viewpoints on this. I'm going to introduce the moderator of the panel, Melissa Rones, and I will hand it over to her from there. So Melissa Rones is a partner at Ropes & Gray, where she counsels life sciences clients on a wide range of intellectual property issues. She also performs due diligence investigations and advises clients on IP in the context of a range of transactions. Melissa holds a PhD in cell and developmental biology from Harvard University and brings that experience and expertise to her legal practice. We're very glad to have her to moderate this panel. I'll turn it over to you without further ado.
Great. Thank you so much, David, and thank you everybody for joining us today. I'm very excited about today's panel. In our prep discussions, we've had some great conversations, so looking forward to continuing that conversation as well as getting questions and insights from all of you. So I won't introduce each of our panelists. What we'll do is we're going to kind of go around the horn, where each of them are going to have a chance to give some of their perspective on particular aspects of the topic we're discussing today and that David teed up. The balance here between the rights of IP owners, patent holders, and others, whether those be other innovators or the public, and how are we doing? Where are we striking the right balances? Are we? And maybe perhaps where are we not? So I think we're going to discuss a wide range of topics. We'll potentially also get some conversation going up here on the panel, and I think folks may be sharing their own views or maybe prompting, being incendiary and helping to get good debate going. So we'll see how that goes. And so without further ado, we're going to get started with Peter Yin. So I'll call up Peter to the microphone, unless you want to stay where you are, Peter.
Oh, I can come over.
Great.
So it's a pleasure to be back here. Let me start by thanking Regina and David. I have to say this is a wonderful conference, even during the pandemic, but it's just not the same seeing all of you guys here. When I got the topic for this panel, my immediate thought is something I've been working on about the COVID TRIPS waiver. And so for those of you who have not been following closely what has happened at the international level. Some countries in the developing world, especially South Africa and India, has proposed a waiver that would waive about half of the provisions of the TRIPS agreement to help address the global pandemic. Initially, our previous administration was strongly opposed to the approach, but that has changed with the new administration, and we are willing to negotiate at least with respect to patent issues in relation to vaccines, but not in other areas of COVID products or technologies. So the immediate reaction, I think, for a lot of those in the legal community, as well as those who have been teaching intellectual property, is that, well, even if we get rid of some of the IP provisions, it's not going to address a lot of those issues, especially with respect to vaccines. Because there's lack of raw materials. There are issues with respect to lack of know-how and show-how, which was mentioned early on by Sean. And I think there are also concern about how likely a lot of those developing countries would be able to develop the technology. I think that's true for most developing countries, but not necessarily true for all developing countries. I think that will be interesting. And I think there are also some in the IP sector who believe that we actually need to have stronger IP protection in order to address the pandemic. And I think that is actually a very complicated question. When I look back at how we are actually doing vaccination, especially on my campus with a lot of the students, my immediate thought is that, well, should we actually want to go for more technology so that we can deal with the different variants coming out from virus? Or do we want to actually make sure that everybody will get at least one dose, if not 2 doses of the vaccine? And I think that's a very difficult issue. We were vaccinating our students on campus at Texas A&M University, and I see a lot of students not showing up for their appointments, right? And this is actually very complicated for me because I've been helping developing countries to address those issues, and they do not even have a single dose, right? And then we also have a lot of doses on campus, and yet not everybody is showing up for the vaccines, and I think that's a very complicated issue. But what I want to do, since I'm an academic, is to get you guys to think about the other side of the debate. So for a lot of developing countries, I think it's reasonable for them to actually think about how we can tinker with the international IB system in order to address the pandemic. We have tried a lot of different things during the pandemic. If anybody knows exactly how to address the pandemic and get rid of the issue immediately, you basically walk the other way, right? And I think a lot of times they were thinking about the fact that the TRIPS agreement provide, for example, compulsory licensing arrangement in both Article 31 as well as the new Article 31 bis. And yet, that provision has only been used by a single country, Rwanda, trying to get drugs from Canada. So, and that provision allows those countries that do not have manufacturing capacity or not have sufficient manufacturing capacity to actually import drugs from other countries, right? So if the provision is available for so long, I think it was proposed in 2003 and it was finally ratified in 2017. There's a question as to how likely it is the current TRIPS agreement can actually address some of those issues. Another concern, I think, from developing countries is that they might face litigation at the WTO. They might also be put on the watch list or priority watch list under U.S. Trade Representative. I think a lot of people take the position that that is unlikely during the pandemic, and yet it becomes very complicated if the pandemic is over for the global north and not over for the global south. What would happen? Right? We already see a number of companies considering taking action since pandemic is more or less over in the global north. And so it's understandable why I think a lot of those developing countries would be very concerned about what's going on there. There are also other issues, for example, whether the countries can actually use that as a leverage to better negotiate with some of the companies so that they can get a better deal in terms of vaccines, or they can get them to get involved in doing more technology transfer through the technology transfer hub. And I think those are valid questions. The biggest difficulty I have when I first saw the proposal is that things are slow at the WTO. The last time we tried to change the rules at the WTO, it took more than a decade before we actually have the amendment ratified. So if they're going to negotiate a waiver, it's more likely about the next pandemic and not about the COVID pandemic. I think any time we can get a waiver that can be adopted very quickly is likely to retain the status quo, right? So I have some concern even at that time. The second issue that I also have major concerns about implementation. How are countries going to implement those provisions? In the US, for example, I'm pretty sure that if we try to do it, I don't think we will try to do it, but if we try to do it, there will be a lot of issues about government takings. In the EU, I suspect people will go for example, the Charter of Fundamental Rights within the EU in terms of looking at property rights as a fundamental right and challenge that as well. And there will also be some potential investor-state disputes for some countries. So I think it will be quite difficult, I think, for a lot of countries to actually consider the options to implement the waiver. But I think the biggest difficulty is that when you look at those countries that have been deploying compulsory licensing during the pandemic, there are only 3 countries: Russia, Israel, Hungary. And they are not the proponents of the waiver. And they are not the co-sponsors of the waiver. So even those countries that have been proposing and co-sponsoring the waiver, they have not even explored a lot of the flexibilities within TRIPS agreement, including compulsory licensing, right? And I think that shows the disconnect between what's going on in Geneva and what's going on in the capital. I think those of you guys who have clients in India, when you talk to them, I think their position is very different from the position expressed in Geneva. And I think that will be quite interesting as well when you look around and see a lot of those countries. So what I want to end on is two different things that will get you to think about some of the issues as well as the panel topic. The first one is the question I get asked quite repeatedly. What is the position China is taking on the waiver? And China is actually taking a middle-of-the-road position. China is supportive, but it's not a proponent or co-sponsor of the waiver. And China's position is actually quite close to a lot of the developed countries. And I think that is actually quite surprising for a lot of those people who are not really closely following developments in China. I think a lot of those new developments have been actually addressed in this summit. So those of you who have been regulars here, you'll probably find that China has been actively pushing for development in the pattern area as well as in other areas. Right? So it's not surprising that China is not that eager to actually waive the protection in light of the fact that some of the companies like Sinopharm, Sinovac, they're actually doing quite well with respect to the development of vaccines. You can debate as to the quality of vaccines, but at the same time, I think they have been very active, so they might not actually want to go for waiver. China is also deploying a lot of different pandemic diplomacy choices in terms of how to address the issue. If the waiver is actually proposed by India and South Africa, that might not necessarily be a good idea to actually go to the forefront, considering that they're not going to get a lot of benefits out of the diplomatic choices. Right? So I think those are the big picture issues we can think about in light of the development, and I think that actually ties into some of the complications that Michael talks about earlier on the first panel. The second thing I want to end on, and in the hope of actually getting some discussion going, is that one of the complaints about the waiver is that even if the patent rights have been waived, a lot of those countries can still not develop the technology. But what we've been teaching in law school is that the bargain in the patent system is that we will have the technology disclosed so that we can actually promote the progress of useful arts. And if the patent rights have been waived, countries can still not develop that technology. Then the question is, well, what is the justification of having a patent system in the first place? So I'll stop here. Thank you very much.
Thank you, Peter. Our next speaker will be Anita Varma, and I'll let Anita introduce how she's going to approach this question.
Thank you, Melissa. Thank you to BC Law School, Professor Olson, and my colleagues at Crimson Gray. And thank you so much, Peter, for setting the framework of this question of the TRIPS waiver, because I think it provides a really good framework to see whether patent rights have gone too far. I am a biotech patent lawyer. I have practiced biotech patent law, worked with the pharmaceutical and biotech industry for over 20 years. So shockingly, my perspective is going to be a biotech's perspective of have patent rights gone too far, or are patent rights absolutely needed? So when I think about patent rights in the context of a startup biotech, I think that patents help in three ways. They help incentivize innovation, they help cooperation, they allow companies to collaborate, and they help commercialization. So what do I mean by each of these? Drug development, there have been many, many studies that show that drug development timelines are really extensive. I do have a slide, Michelle, on the drug development timeline. If you look at this timeline, from idea to marketplace, we're talking over 15 to sometimes 18 years, where a drug is first developed. There is a whole process of how do you even get to that drug. And then if you do find a lead drug candidate, it has to go through clinical trials. The failure rate of clinical trials can be quite high. So the number of the percentages, I believe, is there is almost a 90% failure rate. You're starting with millions of compounds, and you get to one at the end of this 16 to 18-year period, right? So what are the incentives that allow people to invest the time, the hard work, the toil in kind of taking drug from idea to market? I had another slide which is specifically focusing on the road to mRNA vaccines, because I think that has a, we can, since we're talking about COVID vaccines, we can put this in context. The COVID vaccines we've all heard about messenger RNAs, and they are put in a protective shell, which is a lipid nanoparticle. Lipid nanoparticles and mRNA were first put together in 1987. Right? That's how long ago people were thinking about this. It was in 2000 when these were injected in mice, and there was actually an immune response. So it takes a very, very long time to even see, can you put it in a mouse, can you get a response? Then it was, I think, in 2014 when people came up with a better lipid nanoparticle, which was ionizable. Right? And finally, 2016, Moderna came up with their first mRNA lipid nanoparticle combination and started clinical trials for influenza. So that's almost 30 years that we've been talking about the COVID-19. All innovation is incremental. It doesn't happen, there's no real flash of genius that is happening. People are building on knowledge in the art, right? So that's kind of the story of drug development. Now let's take the story of a biotech. And I'm going to take Moderna. Moderna started in 2010, spun out of the MIT, Derek Rossi's lab at MIT, with $40 million in investment. Studies show, 2020 studies from Tufts show that to get the money needed to get a drug to market is about $2.6 billion, okay? With 40 million, there was no way you could get this drug or vaccines to market. In 2013, Moderna got into a number of collaborations with AstraZeneca, got 240 million, followed by collaborations with Vertex, with Sanofi, with a number of different companies that all kept adding to the money that they were able to get as investments. They went public, and then of course, now Moderna is a household name, right, since the pandemic. Same story with BioNTech. Started as a small company in 2008, had to get into this collaboration with Pfizer. They didn't have a distribution channel, they didn't have manufacturing facilities, they did not really know how to run clinical trials. Collaboration was really important, right? So, what makes Moderna comfortable in collaborating with AstraZeneca? As a biotech lawyer, every time I talk to smaller biotechs, they're worried about disclosing their technology to large pharma because they feel large pharma will run with it and they'll just be left holding the bag, right? So Moderna had to be comfortable disclosing their technology. AstraZeneca had to be comfortable in 2013 investing in this unproven technology, right? Putting $240 million into this technology. To me, the core there was the patents that Moderna had that allowed both sides to come to the table and form this collaboration, which then ultimately, led to Moderna being in a position to be able to develop get us the COVID vaccine. So all of that also, it was needed for commercialization. I think there are quotes from Bob Langer, who has, one of my favorite quotes from Bob Langer is about all the problems that affect a biotech startup. So I'll just read it quickly. Every biotech startup confronts a laundry list of obstacles. They can be scientific criticism, difficulty getting grants, manufacturing hurdles, regulatory hurdles, clinical trials not going well, and having difficulty raising money. And Bob Langer says, and the list goes on and on. So that's the story of a biotech. And in the context of this pandemic, I think Peter already alluded to it, was IP rights really the issue that was preventing access, global access to the medicines? Or was it supply chain issues? Was it scaling up? I think India is actually the second largest manufacturer of COVID vaccines. The Serum Institute of India, the CEO was interviewed, and at one point he said the real issue was actually scaling up manufacturing, right? So India ended up, I think, distributing vaccines to pretty much half of the globe. Was IP the obstacle? No, they collaborated with AstraZeneca, right? Again, to me, patents allow for better collaboration between companies. Companies can freely exchange knowledge and allow for access to life-saving drugs. What were some of the other issues? When Peter talked about scaling up, the issue with scaling up, particularly in mid and low-income countries, is if you don't have a manufacturing facility, setting up the infrastructure for that facility, getting regulatory approval, which has to be done because these are drugs that are getting administered to people, right? Safety is key. So there are a multitude of steps that have to happen, even if we allow access to patent law, in that scientific knowledge has to be seamlessly transferred. Regulatory approvals have to be obtained. Regulatory approvals take a really long time. So I am not convinced that IP was really tripping up kind of the access to vaccines. In fact, what you saw was competitors like Pfizer and Novartis and other companies that actually had vaccine manufacturing facilities who typically compete with each other, collaborating so that they could produce more COVID-19 vaccines and get them to the public. And finally, I'll just touch on a couple of other solutions that we already have in place. One is the Bayh-Dole Act, access to federally funded, the government has march-in rights, so can march in and exercise those rights if needed for federally funded inventions. And also they have under section, I believe it is 1498A, they can use compulsory licenses. And a non-profit actually did some FOIA requests and studied the number of compulsory licenses that the US government actually availed of itself during the pandemic. And it looks like there were a number of compulsory licenses that the US government exercised during the pandemic. So again, there are measures in place where you are not drastically, I guess, gutting a biotech's ability to get ready for the next pandemic or bring the next life-saving drug to market. So with that, I will cut it over.
Thank you, Anita. Obviously I'm a biotech patent lawyer as well, so I can't say that I'll have many countervailing views to share, but I think many of the things Anita mentioned and Peter are going to sort of trend through the remainder of this morning's topics. In particular, as Anita said, all innovation is incremental. I wrote it down, and I think that's going to be really important as we track through the remainder of our discussion. So I'm going to introduce Mike Moyer now, who's going to be our next panelist speaking, and among other topics, I think Mike's going to cover some of the things at the time, what's actually happening at the Patent Office and some other proposed legislation. So, so far we've been talking about what happens sort of on the back end, right? When you actually have patents in terms of waiver or how the patent system is used by companies. Mike's going to talk a little bit more on the front end as to what's happening at the U.S. Patent Office and, how we could modulate the system there.
Thanks. I'm going to stay put.
Very good.
Good morning, everybody. Thanks to BC and Ropes and Gray. I'm a law professor at BU, and I live here in Newton. That means that I drive past BC on the way to work. So it's fun. It cut my commute by more than 50% to be here today with all of you. Our topic for the panel is asking the question of whether IP and patent is too strong. And I want to talk about that in a particular, and it might initially sound somewhat odd context. I think that patent protection of mediocre inventions is far too strong. And I'm interested in low-quality patent examination, which allows patents to issue on claimed inventions that might lack novelty or be obvious, or allow applicants to get claim scope that is too generous. So I want to present 4 reforms I think would be desirable and help us move toward improving the quality of patent examination. First, I think examiners should be given more time and better incentives. The European Patent Office gives on average 30 hours per patent for examination, compared to what in the US? The USPTO examiner gets on average 19 hours. So I look at my students and I think if you're doing a paper, a major writing piece, you should be putting in more than 19 hours. And lots of tasks our students are doing, I think, will require more time than that. Professors Frakes and Wasserman have done empirical work on this topic, and they find that the time crunch at the PTO increases patent grant rate. They find that examiners search for less prior art and make fewer time-intensive obviousness rejections when they are short on time. And doubling the time available to patent examiners would decrease the grant rate by 19%. Moving to incentives, examiner incentives are skewed toward grant because the agency is concerned about backlog, as they should be, and they're concerned about revenue, which they probably shouldn't be. If we could fix the system, we could eliminate that concern. And revenue is based too heavily on issuance and maintenance payments. You don't get the revenue you're looking for unless you get a grant. Alison Brimlow at both the EPO and the UK IP office has noted that problem in Europe as well. During times of financial stress, Frakes and Wasserman find that grant rates increased for most large firms that must pay higher fees, and industries and technologies for which patent owners are most likely to pay maintenance fees. Colleen Chen, who's been comparing quality at the EPO and the USPTO, says that the EPO invests heavily in getting quality right. It allocates more examiners, more time, and more checks to ensure that patentability decisions are accurate. The US examination process, in contrast, has a high tolerance for mistakes because it allows applicants to refile their rejected applications and in many cases get these cases allowed. Colleen goes on and looks at EPO grant rates for claims that are also applied for at the USPTO. And she finds the grant rate in the US to be 75% on a particular claim, where its counterpart at the EPO has a 50% grant rate. She also notes that the EPO search reports, which are vaunted to be much higher quality than American search reports, cite non-patent literature at almost double the rate of US examiners. Reform number 2, more resources should be devoted to examining pharmaceutical inventions, and the PTO should work more closely with the FDA. Some of you are probably aware that Senators Leahy and Tillis recently sent a letter to the PTO where they expressed concern that, to quote, inconsistent statements submitted to the FDA to secure approval of a product, asserting that the product is the same as a prior product that is already on the market, can then be directly contradicted by statements made to the PTO to secure a patent on the product. Let's play this game both ways. Let's tell the FDA, don't worry about regulation, intense regulation here, because this product's the same as something that's already been approved. But that doesn't sound so great when you're trying to explain why this invention's not obvious. So you'll have a different tone when you present the same facts to the PTO. So is there reason for these senators to be concerned about a problem like that? Well, let me give you 3 reasons to think that, yes, they should be concerned. It's a recent Federal Circuit decision involving inequitable conduct called Belcher Pharmaceuticals versus Hospira. Inequitable conduct in that case was found when the patent owner made contradictory arguments before the FDA and the USPTO. One key fact in the case was the patent owner's chief scientific officer, who was involved in both the regulatory and patent submissions. And the court apparently believed that he performed an about-face in arguments filed before the USPTO. You know, exactly the kind of concern expressed in the letter. There are more sensational cases. I hope many of you know that the fraudulent Theranos blood testing device, I see some heads nodding out there, it garnered many US patents. Many patents were granted on this technology after it had become fairly apparent that the claim utility of the patent was non-existent. The patent was granted, and maybe some of you know that it was asserted against a company that wanted to try to get a blood-based COVID test to the market. So not only was this patent granted, but it was asserted after it was quite clear that the research behind it was fraudulent. There's a sensational case about fraudulent research about production of human stem cells, which also led to US patent grants. So better communication between the PTO and other agencies, such as the FDA, maybe the SEC in the case of Theranos, could mitigate these sorts of problems. To combine the first reform with the second, back to Frakes and Wasserman, they argue that by spending $20 million to give examiners 50% more time to review secondary drug patent applications, the PTO could avoid $32 million in litigation and IPR costs, and the aggregate accelerated entry of generic drugs stemming from examiners' increased scrutiny would save drug purchasers an estimated $2.5 to $5.3 billion per year. Third reform. Examiners should articulate and place on the record the meaning they give to claims as that meaning is used to assess 102, 103, and other issues. Judge Plager in Enzo versus Aplera noted that broad to the point of inherently ambiguous claim drafting is not just a matter of poor drafting skills on the part of some lawyers who prosecute patent applications. On the contrary, the art of broad claim drafting is a prized talent. He was talking about this in the context of 112B. I want to apply that statement to the context of patent examination. How do I know if a claim is novel or non-obvious? I need to know the scope. If I perceive the scope to be narrow, I may ignore prior art that I've seen and allow this claim to be granted. And it's the skill Judge Plager was talking about of putting ambiguity or vagueness into claim language, which makes it hard for examiners who are rushed in that 19 hours to figure out what these claims mean. Nevertheless, they must know. They can't make the judgment about novelty unless they understand what the claim is, but they rarely tell us. So let's put it on the record that will provoke a response from applicants and help us get a better sense about the scope of claims. Final reform. Applicants should be required or should be incentivized to make claim language clearer for reasons I've just noted. How might we do this? Well, Peter Manel and I, in an article, had a wish list of sort of a template that could be used at the PTO as claims are submitted and you're starting to have pull-down menus and make choices on things like applicants should declare whether a limitation is expressed as means plus function language and explain why functional language using nonce, in parentheses or in quotes, nonce terms like module should not be governed or should be governed by 102F. Applicants should parse each independent claim into its limitations. Applicants should identify a metric disclosed in the specification or known to FOSITA that should be used to understand terms of degree. They should declare whether any terms have a meaning that departs from the standard meaning to FOSITA. They should declare whether a claim preamble is a limitation. They should declare whether disclosed embodiments are illustrations or limitations. And finally, they should designate a default dictionary for use in construing all claim terms that are not specifically defined. Some of those are relatively modest. Some of them will really irritate patent prosecutors who will tell me that I'm setting out a roadmap to help people invent around their claimed invention. Yes, that is what I'd like to do. I'd like to do that with trademark law as well. Disclaimers in trademark law help the second comer navigate around trademark rights. That's the way a property system is supposed to work. You're supposed to set out these boundaries in a way that can be clearly perceived so that strangers don't accidentally stumble into territory that's protected by a patent-based property right. Thanks.
Great, thanks so much, Mike. Even though I will admit that some of your comments do, as a practitioner, make me a little queasy, but it's okay. And I think that's a great segue, though, to our next speaker, who's joining us remotely, Molly Silfen, and I will turn it over to Molly.
Thank you, and thanks to David and all of you for having me. It's great to be here virtually. Sorry I can't be there in person. So I am Senator Leahy's IP staffer. I work on all IP issues for Senator Leahy, and my remarks today are in that role. I am on a long-term loan from the USPTO where I litigate in the solicitor's office. And anyway, that's some of my background. And today I wanted to focus on a couple of things of just having to do with the question of, have we gone too far? Have we gone not far enough? Some of these will touch on what Mike had to say in particular. But and obviously, like in the international context, there are discrepancies among different countries in terms of how likely they are to grant a patent or multiple patents on a given technology. And there's lots of research going into the reasons for those discrepancies and sort of benefits and drawbacks to them. But in the US, I think it's sort of, from my perspective and from Senator Leahy's perspective, we've gone too far in some ways and not far enough in other ways. So on one end, the process of applying for a patent and getting a patent is too expensive, and the hurdles are too high for individual inventors and lots of people around the country. And Senator Leahy has a bill pending to sort of address that concern. It's called the Unleashing American Innovators Act, and it addresses for one thing, just the cost, right? It reduces there's already a reduced cost for small and micro entities to apply for a patent, and this would further reduce those costs and support the patent pro bono program, because obviously, like, a lot of the cost that goes into applying for a patent is not just paying the filing fee to the PTO, but paying an attorney to help you with your patent application process. So it would provide some more support for the patent pro bono program, which was established under the Leahy-Smith America Invents Act in 2011. And then it would also increase outreach to communities around the country by sort of setting up more satellite offices and actually allowing more people to physically be able to reach the USPTO. But I agree with Mike that, and this is particularly salient in pharmaceutical inventions, that the USPTO needs to be doing more to make sure that the patents that it actually grants are representing actual innovation. And as Mike pointed out, one of those is making sure that the PTO is working more closely with the FDA. And this was, as he mentioned, the topic of a letter that Senator Leahy sent along with Senator Tillis to the PTO about making sure that they coordinate, because it's, there's this lack of information flowing between different agencies of the US government where people can kind of exploit that and say one thing to the FDA in order to say, oh, this is not a new invention, you should give me expedited approval. And on the other side, say to the PTO, this is an entirely new invention and you should give me a patent. And so the PTO has announced that it's working on this issue and is starting a joint task force with the FDA and trying to make sure that that there's more communication among government agencies on this. And another area of concern, especially for pharmaceuticals, is that it's too easy to get multiple patents covering the same invention. And this touches on sort of continuation patents in particular, but also some sort of not necessarily technically related patents, but patents that where you have just many patents covering a single invention. Well, from a statutory perspective, 35 USC 101 says that you can get a patent for a single invention. So there's sort of there's an underlying statutory reason why the PTO should be a little more discerning in terms of granting multiple patents on the same invention. But the problem is on the back end that when there are these sort of groups of patents addressing a single invention, say dozens or sometimes even hundreds of patents covering a single invention, it's just much harder to address those on the back end, right? So for a competitor to say one patent is with, maybe 20 or even 100 claims is invalid, or we don't infringe this patent is one thing. But when the numbers of patents sort of ramp up, it becomes more and more expensive and more difficult to deal with. And as Mike was talking about, examiners have limited time, and when they get an application for a continuation patent, they're looking at a patent that has the same specification as one they've already looked at. And the claims might be very similar, and they've already done the research on prior art. And so they kind of often will say, okay, well, I've already done the research on this application granted. And they do very little work on the, either on the question of, is this granting a patent on the same thing that we've already granted patents on, or on section 112 and whether the new claims are actually supported by the specification. So that sort of allows these continuation patents and these groups of patents to proliferate. So there's definitely like a lot of work that needs to be done on that end, and sort of significantly curbing the allowance of continuation patents. And Senator Leahy sent a letter along with I think it was 5 other senators to the PTO asking them to address that concern as well. And so the PTO recently put out a request for comments on ways of dealing with continuations, among other things, sort of in the patent quality vein. So those are 2 sort of initiatives involving patent quality. I think there are a few other sort of odds and ends that I wanted to mention, touching again on some of the things that Mike raised. But so in terms of having more information on the record from patent examiners, I think one other area in which that comes up is in examiner interviews, because so when you're litigating patents after they've issued, you're digging into the entire prosecution history of the patent, and you're looking at everything the examiner said, everything the applicant said, and this whole back and forth, and ultimately that's supposed to tell you why a patent issued, and that can help you down the line in terms of defining the metes and bounds of that patent, because maybe without explicitly defining a term, the applicant sort of implicitly defined a term or understood a term to mean a particular thing in the process of seeking that patent. But the sort of big hole in the system, I think, is examiner interviews, where often you'll see in a record that there's a back and forth, there's office actions from the PTO, there's responses from applicants, and then there's an examiner interview, and there's a short, maybe 1 or 2 sentences saying, we discussed the claims, or maybe a little more specific than that, but pretty vague as to what was actually discussed. And then there's an allowance, and so there's no telling sort of why, and that's all kind of hidden within this examiner interview that happened. So I think having some kind of record of the examiner interview could be helpful. This is kind of a controversial question, I know, among both examiners and patent lawyers, but I think it could be helpful in terms of knowing what was intended by the applicant. I think similarly, there was a pilot program a few years ago about having applicants provide a glossary of terms. So then they would be defining, sort of in charge up front of defining their own claim terms, which would also put sort of more information on the record. The problem there was that it was an optional pilot program, and there was very little incentive for the applicants themselves to use it, because when they put in a glossary, they're kind of binding themselves in the future, and there wasn't really a countervailing reason to do it. So having something more formalized in that vein could be useful. I don't know how you would incentivize people to use it, or if you would require people to use it, but and then one other thing I wanted to just quickly mention on in terms of allowing the examiners to do their job of really thoroughly examining patent applications is there's a rule in the regs. It's 37 CFR 1.105 about requests for information, that the examiner is allowed to request information from the applicants. And that is used very rarely. And part of the reason that's used very rarely is there are these disincentives within the PTO for examiners to use it. So in theory, an examiner could ask an applicant, say, like, "What have you said anything to the FDA about this prior art?" Or, these sort of discrepancies could come to light from just asking the applicants. But under the currently there are at least the disincentives of having to ask your supervisor, and sometimes your supervisor's supervisor, before you even employ Rule 1.105. So examiners could be sort of given a little more free rein to actually use the tools that they have at their disposal. So I think that's all I have, but I'm happy to talk more, or answer questions or anything.
Thanks so much, Molly. Very, very helpful. And I leaned over, Molly, because as you were talking about 37 CFR 1.105, Mike showed me that on his screen, he also had that, and was maybe jumping in for a comment on that, so it's very interesting. And I sort of made a note that I think in probably 16 or 17 years of prosecuting patent applications, I think I received such a request in a case I was handling once in about 17 years. So it certainly, in my experience, is also very rarely used. And I think perhaps in the questions or amongst the panelists, would be very interesting to also hear some of the countervailing views, just in terms of costs and access. That some of these different things that you and Mike have talked about, pull and push in both directions. So, but before we move on to questions and additional commentary for the panelists, introduce our last speaker, Judge Young. So, Judge Young, I'll turn it over to you.
Well, I'm going to stay seated, and I am profoundly grateful for the invitation to attend. Some of you here are, in fact, law students, and I want you to know that this morning has really opened my eyes to an extraordinary range of issues and policy choices. Now, I'm a trial judge. I don't have anything to do with any of that. No, understand. I work for Ms. Selfrin's boss and all his colleagues in the Congress. That's who I work for. And one of the core of my job, so long as they're within the Constitution, is to make it work, what they pass, to give that life, so it makes economic sense, so that what our elected representatives have done functions in the field. It wasn't until we got to Mike and Ms. Selfrin, I began to say, yes, I don't want that. Let's put that in the record. I'd love to see that. Let's go. I don't care if you don't like it. I want to see that. All right? Now, having said that, and I mean it all. This has just been an extraordinary morning. Now we'll come down to the trial judge's world. But in one respect, I'm a poster child for this issue of have we gone too far? And I'll mention it, and then I'll tell you why we have to stay away from it. I am handling a case which is quintessentially an exemplar of what the policy choices are. Only, of course, I'm guided by the law and the Supreme Court and the Federal Circuit. So I have this Siemens Gamesa versus GE case that involves not biotech, but these huge wind turbines, especially offshore wind turbines. Those two companies, and I invite you to read the truly excellent briefs here, they are direct competitors in this. And so we have a case, the jury comes back, knocks out one of Siemens' patents, and finds GE liable on one claim on another. So I enjoin them, because that's what you do, except I carve out the farm that's being built off Cape Cod and tell them, the infringers now, GE, you have to pay a license. And we had some evidence as to what that, a royalty rather, what that royalty should be. And now we've got another one off New Jersey, and we're figuring out, since they're deep into it, and of course there's a great policy in favor of that. That's solar and the like. Now, that's all I'm going to say about that. I can't say anything else. All of that is absolutely undisputed because it's still sub judice. I mean, I've got to decide things in this, and then, of course, they'll appeal. More to the point, while I welcome you, after I'm out of here, talking about it and suggest that it would be a ripe subject for discussion, you can't talk about it while I'm here because somebody may say that's ex parte, and I don't want any of that. So I mention it, no more about that. So what, and I really will be brief because I am so eager for the questions here. We'll talk about something that I do know something about, and that's judicial administration. That is, what can the courts do to improve the process of patent litigation? And I'll be very quick, but I'm prepared to defend all this. And then I have one odd thing, since you invited me, and I get to say it, and I will. So here's the three things on judicial administration. What's the rap on the courts? And it's justified. It has nothing to do with patent litigation. We are vastly too slow and too expensive. Got it? Anything we can do to speed the process up, consistent with a just result, we ought to do. Because the delay, everyone says, oh, justice delayed is justice denied. Of course, that's true. But also, it's expensive. All the studies show that. The longer the case is hanging around, the more expensive it is, and it's too expensive to begin with. Compared to the European Union, we are out of the world in expense. What are some of the things we can do? We have patent rules. District of Massachusetts has patent rules. Why do we have patent rules? Because the bar wanted them. The bar wanted them. They're pretty good. I don't think they're fast enough, but they're good. I commend the District of Massachusetts patent rules to you. And why is the District of Massachusetts patent rules, why is this significant? We have some of the best patent judges in the United States. Make no doubt about it. Judge Stearns, Judge Saris have national reputations in the patent fields, and I dare say Judge Burroughs is of their equal. Also, we've got a low caseload. Fortunately, with the vacancies being filled, and they are being filled, and being filled promptly, we still have some senior judges who haven't lost it and are willing to work and work hard. So we've got the judicial resources. We get our share, but we're not a patent magnet. And if we want to talk straight, and I want to talk straight here, why? Because my court, we're too slow. You don't know what judge you'll get, and your chance of getting one of the fast and best is questionable, all right? That's why people don't file, and you see them glomming to some place where they think they can get action, and also where they think there's a tilt in the favor of the plaintiff. But that's something to be explored. Second, I would advise against specialized courts. I'm all for the Federal Circuit. That's worked very well. I really am a fan of the Federal Circuit. But am not for specialized courts at the trial level, Article 3 courts. There is something, argument there. Specialized courts tend to make up their own rules. The rules deny accessibility to the bar, become more and more specialized and arcane, and are going to freeze the jury out of the system more than they are already. That would be tragic, because the moral force of what the judiciary decrees rests upon our jury system, make no doubt about it. Third and last, the district courts are far too balkanized. A brilliant federal judge says, you look at the district courts, it's like France under the Merovingian kings. I thought that was a pretty good analogy. And then I read recently that France under the Merovingian kings is the inspiration for Game of Thrones. So I'm not really so sure I would go that far. But the fact is, the court, any district court, is concerned about its caseload. That's a tragic mistake, and I'm talking far above patents now. We're to be concerned about the district courts on the border. We're to be concerned, if we get into our recession, about the district courts in the financial centers of the United States. And the judicial resources don't match the where we really have the need. But one thing that came out of the pandemic is everything but jury trials, everything can be done, and I hesitate to use the word Zoom, but I don't know any other word, and it probably will lose its trademark because it's just a common word. We can do it all by Zoom, and we are. And we should do more of it. And the district judges should be encouraged to do more of it. Get the resources where we need them. That will cut down the time. Cutting down the time cuts down the expense, improves the quality of justice. Now the odd point, and this is just personal to me, but I advocate it, you invited me, so I'm going to say it. The way to try a patent case where the patent holder sues the infringer, and the infringer, of course, comes right back and says, oh, his patent's invalid, is to try invalidity first. And then, before the same jury, you don't get the verdict on that yet, because the jury has to hear it all, then try infringement. By doing that, the jury, if you try it the other way, the jury comes in and they start out and they say, well, here's the inventor of this thing. The inventor. Whereas, as you properly have said, all innovation is incremental. If you try invalidity first, they see all the prior art. And you go through the prior art, and you argue over what is this in advance over the prior art. And, because I think it is appropriate, of course, who am I to question it? I just obey. The standard there is clear and convincing evidence. I always say that loud when I talk to the jury. Clear and convincing evidence. Fair preponderance, I can't wave my arms now, but I do a balancing test. And what happens is, a mediocre patent is not likely to survive, because the jury will declare it invalid. But you get a patent that's sound, well, then the infringement, if someone infringes on this sound patent, this is not scientific, but my experience, they're more inclined to find infringement of the valid patent. Then you give the jury both questions. I do thank you. I hope that's helpful.
Thank you, Judge Young, and thank you to all of our panelists. I think we covered a lot of territory and some really interesting questions ranging amongst all of us as practitioners, academics, the judiciary, potential statutory change as well, and the regulatory scheme and practice of the PTO. So far-ranging questions here. We've got a few minutes, so I'd love to open it up to questions, generally or with respect to, directed to particular panelists. Oh, got a question there in the back.
Steve Chow. Having been a practitioner since 1976, I've noticed the change in all the aspects of intellectual property and so forth. One issue that has arisen for smaller independent inventors is that because of the eBay case and the elimination of the injunction, really there's no reason for small businesses ever to litigate. They can't even get litigation financing. So I'm just wondering if there are any thoughts about whether there is some movement to move the idea of injunctions back to some kind of presumption, obviously not automatic, but I know that there's some, the Stronger Patents Act is one of those, but I think that I would speak for that side of things, that we never get to litigate things anymore, because it used to be that if someone took my copyright work, I could say, well, I can walk in and get an injunction. Today they say, sue me, and by the time you show damages and go through appeal, it doesn't really make it worth it.
I can jump in just with a quick comment, which is that another sort of initiative from Senators Leahy and Tillis is it's a study of a small claims patent court that would sort of, so on the copyright side, this was just launched, the CCB, the Copyright Claims Board for small claims. The board is within the Copyright Office. It promises sort of quick adjudication and inexpensive adjudication of small claims. So one idea that is certainly being tossed around and looked at is whether something similar on the patent side would be useful, where you could get something adjudicated more quickly without burdensome discovery, ideally entirely pro se, and that could sort of help to address the lack of injunctions. I don't know that at least under the sort of current law and the Supreme Court's eBay decision, that injunctions themselves can sort of be more freely given. But those are my quick thoughts.
Are you going to comment?
Yeah. Hey, Steve. Thanks for the question. I would be happier with your proposal if we had judges like Judge Young, who used a little creativity in crafting injunctive relief. But I think we don't see that very often. An injunction doesn't have to be all or nothing. And on the side, someone should talk to the ITC about that as well. So injunctions can be pretty harmful if they're not reasonably crafted. I share your concern about high-tech startups, but I don't think that patent law is the place to look for a solution. I think antitrust, the dominance of platforms, increased concentration of industry. We see lots of evidence that startups are not thriving in the U.S. the way they were, and I don't think it could possibly be due to eBay. I think there are more fundamental issues that should be addressed, and I worry a lot about abuses of the threat of injunctive relief in the hands of some of the bad small inventors. There are plenty of good small inventors, but I want something that's more fundamental to improve their lot. So I would not be inclined to support that proposal.
Judge Young?
I have no idea who's bad or good. That's what we have trials for. But one procedural device, if the plaintiff seeks a preliminary injunction, I have been known to collapse that with trial on the merits, and which the rule allows, even in a patent case. and they say, well, wait a minute, wait. We get the injunction now, they're clearly infringing. And I say, no, prove, because you got to prove your right to an injunction. And these cases, don't go thinking that you've got the most complex thing in the world. You don't. The idea that trials work, jury trials work, one of the reasons they work is that you can bring this down to the level of the average American. And that's a damn high level. Don't forget that. They actually work. And I'm a judge who believes in it passionately. We tried a jury case, a jury patent case, 5 months after it was filed. And I believe justice was done. Everyone scrambled, but then I don't mind that.
Great, thanks. Oh, go ahead, please.
No, another question?
Yeah, no, go for it.
I hate to lose the opportunity, since both you and Anita have said you might have some comments on Michael's reform proposals. I was wondering if you could just share one or two, because it's a comprehensive reform proposal. And then I would wonder if Judge Young could then comment and see if he does want to listen to what you have to say or not.
Well, I always want to listen.
Anita?
I think so. I used to be an examiner many years ago, so I completely agree with the fact that examiners, I think, have to be given more time to actually examine their applications, and no argument about improving quality and taking measures to improve quality of the patents that we get is a good thing, right? So no arguments on that aspect. I am the burden to an extent. What I'm hearing Mike say is a burden shifting to the applicant in terms of the number of when drafting a patent application, what additional aspects I have to provide in addition to describing the invention, right? And there, I feel that the office, right, has qualified practitioners, patent examiners, all are qualified, have degrees, and are trained to examine. That burden shifting will make the application that much more expensive, and would access, that we're talking about access to sole inventors and all of that, to good advocacy. How is that going to play out is a concern that I would have.
Yeah, no, and I agree. I think despite my somewhat jesty comment about my own queasiness, I do worry a lot about the cost. Because, frankly, in any industry in which patents are valuable and crucial to the protection of the technology, it's already expensive, and then to boot, if you're the more you need to put on the record, the more you say on the record, particularly up front, before the examiner has even made a prima facie case, the higher the cost and the tougher it will be for small innovators, small companies, startup companies, to have good access. And I worry that ultimately it could tip the balance the wrong way in terms of the bid and the ask in terms of disclosure versus the opportunity for a patent. I also worry a little bit in terms of differential impact in technology areas. And I think this was one topic we all discussed a little bit as a group and hasn't come up yet here today. Some proposals, some of the legislative proposals would be around maybe some burden shifting, at least in some areas, like second generation kind of pharmaceutical patents. But I think one of the other things that you see is just the difference in the timeline, right? By and large, pharmaceutical patents are most valuable at the end of their life, if they're going to be valuable, right? When there's a drug on the market, at the end of the very, very long timeline Anita showed. Whereas, and again, this is an over maybe generalization, but we know the pace of tech, right? Not that, a lot of your tech isn't relevant 20 years down the line. Think of your phones, think of, whatever, all that stuff. And so I also think it puts different pressures on the upfront costs as well as the back-end enforcement costs.
I think the other piece that I will say is on the collaboration between the FDA and the PTO. Again, all for the agencies having disclosure and communication. There is a timing issue in my mind. When I file a patent application, I have no idea whether it will actually be a marketed drug product, right? And the information that is submitted to the FDA is sometimes almost 15 years after the first application was ever filed. So I am curious about how this communication between the two agencies is going to help an examiner in that early time frame assess the prior art. And while I know that there are instances, the Hospira case is a good one where, you know, opposing statements were being made to the two agencies. In the 20 years I've been practicing, I think there's the Hospira case, and there was another case, maybe 2010 or so, where there were such inconsistent statements and it went to the Federal Circuit. So I wonder how many such cases are actually, what is the percentage of those cases where such statements, diametrically opposing statements are being made?
Sure.
Those are good comments. Anita's first comment, it's going to increase the price. I agree. That might be a feature, not a bug. When I say that, I might lose half my supporters, though. But I think the patents are too easy to get. And I think it would be desirable if prosecution costs were pushed up by shifting burdens. I view that as a feature. Although it runs headlong into the problem Molly was identified about marginalized inventors having difficulty navigating and affording to use the system. The comment I made to Steve is the comment I'd make to Molly is that, yes, that's a problem, but there should be a different solution. It shouldn't be fees or prosecution cost where we intervene. We should be intervening through the SBA or something else. There are better policies, I think, for addressing those sorts of problems. Like Anita, I don't have too many cases of this kind of inequitable conduct, but we have many cases of publication patent pairs where scientists publish and they also patent, and there are retractions in the scientific literature, but that retraction is never communicated to the PTO. It somehow should be, and it should have some impact on examination, and it doesn't. Anita says that often examination is here, and a decade later we get FDA activity. That's right, except that's not right for the many continuation patents that Molly was talking about before. So I certainly acknowledge the trade-offs, and we do have to make hard choices about what the right balance is.
I have time for one more question if there's one more. All right. Which we'll have to deal with quickly.
All right, I'll try to be quick. So in recent years, there's been acceleration of the application of big data to patent examination, digging down to statistics like the allowance rate of art units and particular examiners and how they behave under certain petitions and whatnot. Do you guys personally, or perhaps if you know about the USPTO, see this as problematic in any way? Or do you see it just as a natural evolution of applicants trying to optimize their patent filing strategy? Because this data applies not to the merits of the patent claims, but kind of ancillary effects of how the USPTO operates.
I mean, I'll jump in really quickly on one thing that I've seen happen is that, people have access to all sorts of data about like what examiners are more lenient than others. And then they also can analyze what keywords they can put into an initial set of claims that they will then change later. But just throw in some keywords that they know will target a certain examiner that they know to be more likely to grant an application. So I think that becomes problematic when that sort of gaming can be done. I think there are ways to counteract that also through just, maybe the keywords that the PTO uses should come from the spec rather than from claims, since claims can be changed later. I think there are ways to deal with it that are, where you can still use these sort of automatic assignment abilities and certainly save a lot of work that way.
I just second that comment, and I'll give you a little bit of history. Back before we were using machine learning, we had the second pair of eyes program, where business method patents were getting more intense review. And even with less sophistication, it was already clear applicants recognized that this was an issue and then wrote their applications in different ways to avoid second pair of eyes. And this is not so different from Google and websites and the prominence of your website. People are trying to hack the search algorithm, and then the search algorithm changes. So there's a kind of cat and mouse that I think will continue to exist. So it's not a good thing, but maybe not such a terrible thing or something we can handle. I think the really interesting thing to wonder about is machine learning. What's that going to do for search? The PTO will no doubt, I think, do a better job with search because of tools like that being available. But I think ultimately, machine learning won't be so helpful with examination because the algorithms aren't going to know better than us what the Federal Circuit thinks that claims might mean. Maybe I'm wrong, but I'm not optimistic that machine learning tools are going to be especially good at telling the world what claim language means.
Okay, well, thanks everybody. Thank you to the panelists. This was, from my perspective, a great discussion, and I'll turn it back over to Dave.